Okay, oop. We ready?
Yeah, we're ready.
Okay. Well, welcome. This is, Doug is not quite right. We've got one more of these elaborate setups coming up next month, and that'll be Margot McDermott and Mike Connolly, Senator Mike Connolly, talking about how you deal with legislation.
And then here we are, the judges, to interpret the laws. Three basic levels of courts here in Illinois. We start at the trial court level, which is where I sit. That is where everything comes through the court system. We talk about how gun laws are affected. Well, every lawsuit starts at the trial court level. Right now in Illinois, there are 24 circuits, that's what we call the trial court level here in Illinois, out of 102 counties, which means some circuits have up to 12 counties in their circuit. Ours is the 12th Judicial Circuit, and we have one county, which is just Will County. The cases that come and go through the trial courts are either criminal in nature or civil in nature. Criminal is obviously pretty basic. You know, someone violated the law, and the state's attorney's office or some local prosecutor is prosecuting them for the crime. Could be anything from a petty offense, which is punishable by just a fine, to misdemeanors, which are punishable by up to a year in the county jail, to felonies, which are, as I said before, up to murders, which is potentially natural life, because we had an anti-capital punishment governor not too long ago who took care of that. We also can handle civil cases, which are when people are suing each other over certain things, car accidents to the railroad crash in Plainfield where oil is spilled and NICOR is suing CN Railroad or vice versa. Right now in the state of Illinois, the last figures I have are that in 2015, there were 2.7 million cases filed in the trial courts of Illinois. Out of that, there are roughly about 700 or so trial court judges. So when you start doing the math, you realize that there's a lot of stuff that comes and goes through the trial courts that we kind of shuffle through. The next level is the appellate court. In Illinois, we have the appeals of anything that happens in the trial court goes to the appellate courts. We call them the district courts. There are 5 districts. Most of them are, well, the first is Cook County, and you're going to hear as I tell you a little bit later about the Supreme Court. Cook County generally has more than their share of say in most of these things. Cook County has its own appellate district. We call it the first district. The rest of the state has to split up the other 4 districts. Our district here is the 3rd district, and it encompasses 21 counties, and it goes from the Indiana border with Kankakee and Iroquois County all the way over to the Mississippi River with Rock Island and Galesburg, Peoria. Those are the county or the cities in between. Out of those 21 counties, all the appeals from our trial courts go there. They're generally heard by 3 appellate court. We call them justices. Apparently, trial judges are just judges, but once you get to that level, you become a justice, as if you're some way, shape, or form wiser than the rest of us. And that's a little, those of us who sit in the trial level always say about appellate justices that, well, they've never seen people accused of a crime, victims of crime. They don't sit there and see it, because I'm about ready to tell you, they don't deal with any evidence. All the facts of the case are always put in at the trial court level. Very rarely on the appeal will they allow certain evidence to be brought in. So everything in a case, before it even gets to the appellate court, the record is made at the trial level. And then you have 3 justices on the appellate court who will generally review the record. Everything that's said, and I think Ed's going to talk about this, everything that's said in court is written down. Everything is transcribed by court reporters, and any appeal is based upon whatever's on that record. They can decide whether or not to have oral arguments. Oftentimes you'll see in the TV, the guy standing up there in front of the court yelling and arguing. Well, at the appellate level, they don't even have to hear that. They can actually say, no, we don't even want to hear it. We've read the record, we've read the appeal, we're just going to make our decision off of that. Couple of things, and I'm kind of rushing through this because I don't want to cut down on anyone else's time. But a couple of things that you have to know about the appellate court And mind you, now this is coming from someone who I've now been on the bench for a little over 4 years and has had my share of dealings with the appellate court and the Supreme Court telling me that I've done stuff right or wrong. But it's kind of interesting to me because the appellate court has the ability to review a case from the trial courts, tell them that they did something right or wrong, but they can also do it in a way where it doesn't apply to any other cases. Generally, we believe that whatever the appellate court says is the new law, or it's a reaffirmation of the old law. But we've have a flurry, I will say, of cases here in the 3rd District, especially, that they use a special rule in the Supreme Court rules called Rule 23, where it basically says, well, we're going to tell you what you did wrong, or we're going to tell you what you did right, but we're not going to make that applicable to any other cases. And they use that all the time. It's one of those things that, you know, as a trial court judge, you say, well, listen, if I screwed up, tell me I screwed up and make sure that we don't screw up again. And so those are all things that go into play when appellate courts make their decisions. If they do publish the case, it becomes the law of the state if there's no other appellate court decisions and or if the Supreme Court hasn't ruled on it. In 2015, there were 7,452 appellate court cases filed throughout the state. The third and the top level of the food chain, if you will, is the Supreme Court. We've all heard of the Supreme Court. We all know that is kind of the court of the state, that everybody looks to it and says, these are our fearless leaders in the judiciary, and they're going to tell us what the real law is. Well, like anything else, the Supreme Court, being the top, has some interesting things that they can do. First and foremost, it's made up of 7 justices. 3 of the 7 are from Cook County. The other 4 come from each of the respective appellate districts. And generally, the way it works, it's ruled on, and the majority of the 7 dictate what the law is. As a sitting judge right now, I can't get into politics. I can't get into some of the things that I'd like to tell you. But it just goes to show you that it's very, very, very important that those of us as private citizens know that who sits on the bench and who make these decisions, that we have to know who those people are. We have to know their backgrounds. We have to understand what some of their philosophies are. You know, oftentimes we'll hear that in federal court issues because the president appoints them. There's Senate confirmation hearings. But for those of us who run locally, the same thing holds true. And everybody, with the exception, well, all of the circuit judges, appellate court justices, and Supreme Court justices are elected by the people. And then for people like me on the trial court level, every 6 years we're up for retention, which means that the public gets to decide whether or not we should stay. We need 60% of the vote, yes or no, after we've been elected from a general election. Supreme Court and appellate court is every 10 years. And it's always important, like I said, to make sure that you know who your judicial candidates are and make sure you understand where they're coming from. Because as I said before, everything, whether it's taxes, whether it's guns, whether it's any issue you can imagine, you always hear where someone says, we're going to challenge this law by filing a lawsuit. It starts with a trial court judge. The Supreme Court had 2,402 cases filed, and here's the greatest thing about the Supreme Court. Once again, it's good to be the king. They don't have to hear any of them. They can decide and they can pick and choose which cases they want to hear. And so the Supreme Court, I don't know exactly how many they heard in 2015, but they decide based upon what was presented to them whether or not it's even worth hearing or whether they just let whatever the appellate court did just stand. Well, I think we're going to get to questions, right?
Yeah, we'll get questions.
I want to make sure that everyone gets a chance to get their time in. Just one last thing about our little judicial system here in Will County and the surrounding counties. Sometimes people don't understand, how the judges are picked or chosen or those sort of things. Well, in Will County, we have, I think 36 judges right now? And out of the 36, 16 are elected, those like myself who are circuit judges. We then choose the 20 associate judges. We vote on it as the 16 circuit judges as to who are the associate judges. In the old days, it used to be where the associate judges did the smaller things. They didn't have the authority to do felony cases, those type of cases. Now, everybody gets to do anything that they're assigned to do because, quite frankly, we now have a county that's a lot larger than it used to be and has a lot more crime than it used to have. And that is really kind of our focus on a lot of things, and that is making sure the laws are followed to protect the law-abiding citizens of the county. So,
We need more judges.
well, thank you. That being said, I think I should be right about time, and I will turn that over. If anyone has any questions, I think we'll have a
Yeah.
chance to answer later on.
Ed, prosecutor.
Yeah, my name's Ed Ronkowski. Most of you know me. I've been a lawyer since 1974 and spent 3 decades as a prosecutor. First 4 years in the Will County State Attorney's Office, the last 22 and a half years in Cook County. I'm going to tell you not what a prosecutor does, because you already know he calls witnesses, he files charges. I'm going to tell you facts about prosecutors so you can understand why they do the things that they do. Now, first, the bad news. In 1983, the appellate courts first enunciated a principle that is still good today, and the case was Levas versus Petka, a case that decided that a state's attorney could hire and fire his assistant state's attorneys for political reasons. And in that fact pattern, Bob Levas was fired because he didn't work hard enough for the boss. So you're dealing with a political system. These prosecutors that are in court, and when I was in court, I had defense attorneys in a typical felony case. They would make what I would make in a month or two in one case. I had defense attorneys on murder cases that would make more than I made in an entire year. For when I first started out in the prosecution, for decades, they had caseloads. A prosecutor to have 25 cases, maybe 50 cases that he'd have to work on over a year, and they'd roll over and get new ones. But in the 1980s and 1990s, they just started an influx of filings, a lot of it in Cook County. And it's not uncommon in Cook County to have prosecutors with a turnover of 1,000 cases or more in a courtroom. And this is being handled by 3 lawyers. So these are very hardworking and busy lawyers. These prosecutors, they get judged by their bosses by 3 things. They look at the prosecutor's conviction ratio compared to the other prosecutors in similar courtrooms. They would look at if the prosecutor made some mistakes and got bad press. They don't mind if you make mistakes if nobody hears about it, but if the press picks up on it, you're in deep trouble. And they also look to see if you follow the boss's orders. When the prosecutor is in court, and the court reporters, they take down every word that's said, and they usually have backup tape recordings. And I've seen cases where the boss will tell a prosecutor to make a certain argument in court, and then later on order the transcript to see if he did it. So that's the bad news. Now, the good thing about being on the prosecution side, number one, the police rarely build a case against an innocent man. I've had over 14,000 cases I convicted, and I can only recall 2 cases where we had the police build a case against an innocent man. It's quite rare. Because of the heavy caseloads of these prosecutors, this assistant state's attorney that you see in court, he has no personal animosity towards the individual defendants. He's just too busy to do it. The exceptions to that rule are just absolutely rare and notable in that it's rare. We had one case we were prosecuting. The police raided his house with a search warrant. He had 1.3 grams of cocaine in one bedroom and a gun in the other bedroom. So they charged him with armed violence along with the possession and all that. Armed violence, his minimum sentence is 6 years. He had a bad record, but there was no violence in this thing other than the name of the statute. And we offered to reduce it and give him 4.5 years in the penitentiary. And halfway through the plea, he told the judge he changed his mind and wanted a jury trial. Well, my second chair was a nice Irish girl, said she needed some jury trial experience, so she put the case on. And when the jury was out and they were arguing motions and all that, before the final verdict and closing arguments and all that, the defendant leaned over and told the female prosecutor in a stage whisper, exact words, "You're a honky motherfucker and ugly to boot." That riled her up. Well, they convicted the guy, and he had one Class X conviction. This is second Class X, and they have this rule in Illinois, 3 Class X's, and it's natural life. So normally you take the rap sheet you have at face value, but there's an error rate. Well, she spent a day and a half calling all the jurisdictions that ever arrested this guy to find out what happened on the charges. And it turns out the thing in 17 years ago, there was a burglary arrest that was actually burglary of an occupied dwelling while armed with a machine gun, a Class X. And if she could prove that beyond a reasonable doubt, he gets natural life instead of like 6 years in the penitentiary. So she convinced the office to fly in this old gray-haired prosecutor who was a Mormon bishop on the side from San Diego to testify. And we had a certified copy of the conviction, and he identified the defendant in court. The poor public defender did not want to go down in history of having his client get natural life for 1.3 grams of cocaine. So he had to shake the identification. So I'm sitting in the courtroom watching because I know what's coming up. And the public defender asked this gray-haired prosecutor, "How old are you, sir?" He said, 58. "How long have you been a prosecutor?" He says, "Well, since I was 24. And he says, "How many cases," he asked him, "have you prosecuted in your whole life?" And the guy goes, "I don't know, maybe 25,000. "How long ago did you prosecute my client here?" And he has the fumbles. He looks down at the certified copy. "That was 17 years ago. "How many cases have you prosecuted in the last 17 years? He said, "I don't know, 15, 16, 18,000. If you ever heard of it, he should have let it alone at that point. He asked the following question: "Sir, how do you expect us to believe that you could identify my client for the last 17 years after you've done some 15 to 18,000 convictions?" And this old gray-haired prosecutor leaned forward with a southern drawl and a slow voice. He says, "2 reasons, counselor. In the years in the last 20, since I was 24, I've only prosecuted 1 case where the guy committed a burglary of an occupied dwelling, and it was your client. Then his second reason, in the 58 years I've been on this earth, I've only been sued civilly once, and it was your client." He got natural life. The moral of that story is, do not make it personal with the assistant state's attorney, and if it's a female, don't question her beauty. Okay. Now, the more good news, the assistant state's attorneys are governed by the canons of ethics. And the canons of ethics prohibit a prosecutor from prosecuting somebody unless there's probable cause. And that's because in 1791 they passed the Fourth Amendment with the Bill of Rights that you have to have probable cause to arrest somebody. Since 1983, the U.S. Supreme Court ruled that the prosecutors have a mandatory obligation to turn over evidence negating guilt and tend to diminish the culpability. So the prosecutors can't hide any evidence that negates guilt and has to turn it over promptly. And there's sophisticated rules that are evolving limit what the prosecutor could say to the press. If the prosecutor, even if he's under orders, violates these rules, he could lose his law license. Now, because of these heavy caseloads and all that, I could assure you 99% of the cases that are handled in a criminal courtroom, typical criminal courtroom, is based on the law and the facts. And it's rare that you have an exception. Now, to give a cynical example of this, a judge who is no longer a judge, who came up through the Democratic Party, used to be a police officer and a detective and a prosecutor. He had a murder trial in his courtroom where between the victim and defendant, one was the son of a state senator and the other one was the son of a member of the Illinois House. And he called the prosecutor and the defense attorney in and said, I got so many calls from both sides, we have to judge this one on the facts. We need a jury trial. I'm not taking any heat on this one. And that's exactly what happened. Now, because prosecutors, the state's attorney gets elected, usually runs on his conviction ratio. The prosecutors in courtroom run on, get promotions because they get a lot of convictions. One year in our courtroom, we had 98% convicted of the cases randomly assigned to us. Because they are worried about their conviction ratio, rarely is a case charged because they have probable cause. They usually provide enough proof that almost guarantee a conviction. It's not uncommon that these courtrooms that you go to where they have 90, 95, 98% conviction ratios. Now, in Cook County and in some counties, you have what's called a jury tax. And a judge will tell a defense attorney, if you plead guilty, I'll give them the minimum sentence, like an armed robbery, 6 years. If you go to a bench trial and I find them guilty, I'll give them 12. If you go to a jury trial, I'll give them 18. And I've seen judges say that. In Cook County and in some counties, they've now institutionalized it. It's permissible throughout the entire state. You have a 402 conference based on Supreme Court Rule 402, where if the defendant agrees, the prosecutor and the defense attorney go back and they pre-try the judge, and the prosecutor says what his case is about and how bad the defendant is, and the defense attorney will say about his client, and the judge will say, okay, I'll find him guilty, and he could get so-and-so sentence, and work out a plea, kind of arbitration. Or he'll say, okay, if you go to trial and this is what you prove, this is what I'll find him guilty. If it's something more, and you're not telling me the truth, it'll be higher. So they kind of pre-try the case, and a lot of cases are disposed that way. Now, I want to end with the good news that I have that happens here in Cook County. Many years ago, Doug Mayhall and myself went down and made a presentation in front of the Will County Board in favor of a resolution supporting the Second Amendment. And we talked about how many members of the Illinois State Rifle Association and their families are here in Will County. After our presentation, we left, and literally as we were walking out of the county boardroom, Jim Glasgow, the state's attorney in this county, ran out and stopped us and said to us, he says, look, if you guys ever think we've overcharged a case, or this case on a gun case that defendant shouldn't have been charged, or there's extreme mitigating factors, before you start doing something like picketing the courthouse, talk to me and I'll look at it, and if it's that case, I'll work with you. We won't have any travesties. And we thanked him. He's the opposite political party of mine, and I'm not here to tout his thing, but we had a case where the facts as rumored showed that the guy was grossly overcharged. And the next day I talked to the chief deputy, and he says, hey, you got the facts wrong. Call me Monday. On Monday, he gave me all the facts. Later that day, I talked to the defense attorney over the phone, confirmed the facts, discussed it with Doug, and we both came to the opinion that this case was going to end up, the jury would find the guy guilty of second-degree homicide. And that's exactly what happened. So I'll end it with, if you got a case that's overcharged, talk to Doug, talk to me. The state's attorney will listen to you, and he'll do the right thing.
Your turn. Reagan, defense.
Good evening, everyone. My name is Reagan Freitag. I was a former defense attorney. I also practiced family law. I was also a member of the county board until recently. This past March, I became the chief of staff of the county board, so I'm not practicing as of now. Actually, Dave and I don't know if Judge Carlson mentioned, but he used to practice criminal defense, and even one time we co-counseled a case early on when I was practicing. So he was a great mentor of mine. So, and then lucky me, I got to practice in front of you as a judge too, which was fun. First and foremost, I'm going to have to argue with the prosecutor here. I'm not sure what defense attorneys he worked with that were making that much money, but I'm still paying off my law school loans.
It's confusing with expert witnesses.
Yes, that's it. Secondly, he says that he doesn't believe that the police officers and/or the prosecutors go after innocent people. I don't want to say that they go after innocent people, but I'm sure Judge Carlson, in his prior years of practicing, will agree that we've read some very interesting novels. Maybe our clients weren't 100% innocent, but those reports were definitely flourished. Thank God for technology, and that was always fun. First you'd get the police reports, and then eventually maybe you'd get a DVD, and they were two completely different stories, so that was always interesting. Now with technology, it's nice for not only the attorneys, especially for the judges. When you present that evidence, it's almost like you're right there, so that is definitely more credible evidence to present in front of the judge. I'm going to kind of take you through a day of representing a client, not a day, I would say the process of when I first initially get retained until the disposition of a case. As a defense attorney, I would say that we're usually on 24/7. People don't choose when they're going to get arrested. It's not Monday through Friday, usually on the weekends and usually after hours. So it can be tiring, not just on us, but on our families. But it's what, and a lot of us defense attorneys get a bad rap, whether, attorneys themselves do, and then defense attorneys sometimes we do. But I believe I chose this because I'm a constitutional lawyer, and everyone has a right to that defense. If you can't afford a private attorney, you can fill out an affidavit in court, and you have a right to be represented by a public defender, and we have some great public defenders in Will County. So again, it's our right, and it's something that you can defend yourself, but we all know what that prior president said. So I would encourage anyone, if they were to get in a situation, or your family members, to please, before talking, before doing anything, speak to an attorney. Usually the first thing that happens is the arrest, whether you're getting that call in the middle of the night or a call in your office. The first thing you want to do is talk to that person first, and if it's over the phone and you can't talk to that person, if, they're in jail and you're talking to family, you try to express to them, stop talking. Wait till I get there, or wait till you come into the office. If there's a jail visit in Will County, we can go to the Will County Jail, and it's video court. You're not, and the conversation between the attorney and the client, it is on, it's through a phone, but the sheriff's department shouldn't be listening. It's an attorney-client privilege attaches even right away, even if that client did not retain you. So, if the client comes in your office for an appointment, I always preferred for them to bring family. If we were representing children, of course, their parents, or, a husband or wife or somebody. This is a situation that's going to affect not just that person, but your entire family. So I find it very important to bring that family into this, because there's going to be a lot of family decisions that are made. The first one is how do we pay for this attorney if it's a private attorney? What do things cost? Different attorneys cost different amounts. I encourage you to shop around. I encourage you to, ask your family and friends. Don't look at the billboards. Really, I believe in referral is the best way. And yeah, of course, your more experienced attorney is going to cost more. Usually, criminal defense attorneys charge a flat rate. So I'm just going to say maybe a misdemeanor, say like a DUI, a $2,500 flat fee. I think is still the going rate possibly for a first DUI. Now, $2,500, maybe somebody doesn't have that up front. A lot of attorneys will, take an initial retainer and then work out a payment plan on a monthly basis with you, understanding that, we don't have money trees in our backyard, but they really want to help you. So, let's see, the next thing, in that meeting, I always tell my clients that, now remember, this is not like Law and Order. It's not like the first half hour the crime was committed and the second half hour the trial. If it's a misdemeanor, it could go up to 6 months. If it's a felony, my goodness, I've had cases for more than 4 or 5 years. I mean, I know, I was just talking to a prosecutor today, I think, one of our colleagues is working on a 2012 case that's going to trial pretty soon. So, I mean, it's, don't expect instant gratification, that's for sure. And that's the most frustrating thing. But, make sure you find that attorney that you have that constant communication with, because that is what's going on. Someone make sure that attorney is getting back to you, because it is a scary experience. So communication is very important. The next thing would be the first court date. Usually would be the bond return. So say they got arrested for a DUI. Usually that person can pay the bond at the police station. It's a lower amount and be released. Unless it's a higher crime, then they're in jail and there's a bond return date, and that's your first court date. And at that court date, the attorney appears, not much happens. If you're in jail, a lot happens. We try to get you out. And say the bond is set at a certain amount, it's our job to try to negotiate that beforehand, before approaching the judge, to see if we can get that bond reduced. We do that by saying this person's in school, not gang-related. We can put additional non-monetary bond requirements on them, say, they have to wear a scram device. It's an alcohol detector, that they can only leave the house for school, church, different reasons like that, to bring down the amount of money, because this person is now paying a private attorney. There's a lot that goes on, but they're willing to do all these things to show the court that they will come to court and they're willing to obey the rules of the court. So, let's see, after that, at that hearing, the attorney files their appearance. Hey, I'm here, I'm their attorney. Hey, prosecutor, you're going to communicate with me now. They ask for discovery. That's usually the first time discovery is your police reports, DVDs, evidence. At that point, you guys give us like a 2-week date. You don't get it in 2 weeks. You don't get it all in 2 months. It's funny how it just trickles in, but you want that defense attorney that's going to be on that prosecutor saying, hey, give me my stuff so we can get through this case, whether we play it out or set it for trial. I need to get ready for this. It's that period of time that is hardest for that individual. Okay, what's going to happen next, After that, you're going to have a series of what's called pre-trials. Trial. It's their court dates. And we try to work with our clients, what's good for you. Are Wednesdays good? Or Thursdays? If they're in school, work. We try to set them anywhere from 30 to 60 days. And what that is, that's our time where we're in court talking to the prosecutor and letting the judge know, the judge can get on us too, what's going on, hey, prosecutor, have you tendered this? Or, say the defense attorney sent out a subpoena. It's kind of check-in time to maintain the case and to keep it going. Also during that time, you can also set motions before a trial date. So there's, in a DUI, you can set what's called a petition to rescind. That's almost like a motion to dismiss to save somebody's license, and there's a timeliness to that. So that's an early motion. So you file a motion to prevent something from happening or to get something to happen. And so what they're kind of like mini hearings. And we have them in front of the judge. A lot of times our courtrooms are so packed. Thank goodness we're getting a new courthouse. Because right now, if I have a trial or hearing date set we set them at 9 or 9:30. Dave's courtroom is packed full of the pretrial dates, right? And so he wants to get them out, and then he'll start me when he can, and he does his best. Or there's other judges floating around in different courtrooms, so maybe they'll send me to a different courtroom to try to keep the process going. And it's, it just depends. Say a petition to rescind hearing or a motion to suppress hearing could take, maybe, typical lawyers, we say an hour, and then it ends up being 2. But a lot of times we wait around, our clients wait around, our police officers wait around. So hopefully with this new courthouse, it will be a much more efficient process. So then at some point, as you get this discovery, my suggestion is to constantly meet with your attorney. Not every little, I got one additional police report. What I would do is when I got a big chunk of stuff, I'd have my client come in and I would make copies, and I would have, I've already reviewed it. I'd have my client sit in the room with a highlighter and pen and have him or her mark it up and say, this happened, this didn't happen. I wasn't there. They were. So it's your obligation too to help your case and to, help me help you. So then we talk about it as the case goes on, and at some point, I think the best position is when I can say, look, I worked out a deal with the prosecutor, or I'm ready to go to trial, and it's a hard decision for that client. And that's when the family decision comes in, and it's a matter of, as my dad would say, a bird in the hand or 2 in a bush. So at that point, it's ultimately, I will counsel you to the best, but it's your decision. Thank you.
Did it?
Yep.
No. I'm David Lombardo. I do work as an expert witness. Let me tell you, this is all very intellectual. It was very nice. Let me tell you what your day in court is actually about. Your day in court is you hire the best attorney you can afford who works out of his kitchen because he can't find a job. And you're going up against the prosecutor who's up for re-election, and he looks at your case and he goes, this is above the fold in the paper. I'm going to get re-elected, putting this guy away in a slammer for life. Before a judge who just had an argument with their spouse before they walked through the door, in front of 12 people not smart enough to get out of jury duty. Okay? That's your actual day in court. Now, maybe I'm being a little glib here, but I was on a civil case. This is a long time ago, but I was on a civil case, and these 2 attorneys were at each other's throat. It got to the point where the judge was going to hold them in contempt because they were yelling at each other and just, really going at it. And I'm just sitting there, keeping my mouth shut because I thought the judge was going to burst a blood vessel. And then finally the case ended, and my attorney and I are walking out the door, and the other attorney, who 10 minutes before was in a blood battle with my attorney, hits the door at the same time, and he goes, Bob, you want to go to lunch? Yeah, sure. They're all friends. They all know each other. There's a giant amount of, excuse me if I say this, but theatrics that go into this. And if you don't think money matters, who you pay, how much money you pay to get the best attorney you can find, it has a sort of a profound effect. As an expert witness, what expert witnesses do is they have either the knowledge, they have the skill, they got the training, they have the experience, or at best a combination of all of them on a given subject. So I do Second Amendment and firearms, lethal force, that kind of thing. The average, I went and looked this up. So the average expert witness, medical expert witness right now across the country makes $555 an hour. And the average non-medical makes $248 an hour. So I charge $300, just a round number, it makes sense. And when an attorney calls me and tells me what he's got, my response is, send me all your stuff. I charge a flat 2 hours to read it, and then I'll tell you what I think. And people say, well, I do civil and criminal. And people will say, well, you defend criminals? And the fact is I do not defend anybody. What I actually do, and I think this is probably true for most expert witnesses, is I look at the material and I feel that everybody, whether they're guilty or not, everybody has a right to have the truth told at their trial, insofar as I understand it to be. And so I will review the material, and then I'll call the attorney back, and after the check clears, of course, I'll call the attorney back, and I'll say, this is what I think. Sometimes they hire me and sometimes they don't. People have some people have this conception that an expert witness will, I'll say lie, but they will, yeah, lie, I suppose I would say, to get a criminal law. And I won't say that's never happened, but all you have to do is do that on one case and get caught, and that's it. You're done forever. Plus, it's perjury. So it's not worth it. But I'm sure attorneys, and I don't know because I'm only one expert witness, but I'm sure attorneys shop around for experts because they look to find somebody who agrees with them. So if I get hired, it's because the way I view the facts of the case, my opinion helps that client. It's a long, arduous process. I mean, you meet with the attorneys and you talk about what the issues are and you explain it to them, and particularly firearms. I have met very few attorneys. Ed would be one of the very few attorneys that I know that actually understand firearms. Most attorneys do not. Now, there are attorneys that specialize in Second Amendment issues, and they typically do. But most of the criminal work, particularly, are done by attorneys who just do a wide swatch of criminal law, and they don't know anything about firearms. And so I find myself having to not only educate, a jury, but I'm having to educate an attorney. I'm having to tell them what questions to ask and what to go after on the other side. It's very specialized stuff. And the thing that's, I don't want to say it's a stacked deck because that's unfair, but it is Illinois. Because it's very technical stuff, some judges won't allow you to use certain terms. And I'll give you a good example. I had a case where a guy was driving on Roosevelt Road, minding his own business. And then, this is before concealed carry. And in the center console of his car, he had a firearm with ammunition, but not in the gun. So under Diggins, it was the Diggins ruling, he was legit. And he's driving along, and somebody intentionally, in retrospect, tries to run him off a road. This is on Roosevelt Road in Lombard. And runs him onto the curb. And then slows down and does it again to the guy, and does it a third time, and now he's got his window open and he's giving him the finger and he's yelling at him and stuff like that. And our client had no idea who this guy was or what he did to get him so angry. So after the third time, when the guy goes, you this, you that, he picks up his cell phone and he calls 911. And he says, hey, I'm on Roosevelt Road, I'm in this area, this guy 3 times has tried to drive me into off the road, he's threatening me. And then he makes the big mistake of saying, look, send the cops out here, get this guy, but I have a firearm in my car, and if this guy comes after me, I'm going to use it. Well, guess who they arrest? They arrest him. And when we, when we went to talk about the case, the whole thing hinged on the fact that when he put the magazine in the gun, he didn't put one in the chamber. Now, my claim was that's an unloaded gun, because you can pull the trigger all day long, nothing's going to happen. So we go into court, and I am, cross-examined, we talk about it. This is before it goes to trial. And I say that, and the judge says, I'm going to allow your testimony, but you can't use the word unloaded. That's the whole defense. The whole defense is the gun's not loaded. She would not allow me, this was in DuPage, she would not allow me to use the term unloaded. So, this is something else an expert witness can do. I went home and I did a video of it. And I used, holding the gun, never used the word unloaded, but showed very clearly that the gun was unloaded. Showed how you put a magazine in and it doesn't pour in the chamber and all that kind of stuff. And they gave that to the prosecutor, who looked at it and immediately dismissed the charges. So it's a game of one-upsmanship. And the words you use, not only do you have to know what you're talking about, but you have to really be good in transferring your understanding to the understanding of the jury. So you can have somebody that knows everything that there is to know, but if they're not good at making juries feel good about them, it's a losing proposition. So it's part, I think it's fair to say it's part theatrics and it's part knowledge. What else have I got? So that's kind of what an expert does. I don't defend people, I just tell them what I believe to be the truth is. Yeah, I think that's probably pretty much it. The one other thing I'll tell you is this. Oh, for God's sakes, don't ever be your own attorney. The pro se is like, you might just as well go ahead and get outfitted for the orange suit before you go in. But you got to listen to your attorney. We got a case now, it was somebody that Ed used to work with in Cook County, the attorney, who's not the criminal, who killed his wife, and he claimed the gun went off by itself. And when the attorney called me, I said, you know, for $300 an hour, I'll come to your office right now. I own that gun. I'm going to show you why your two best words are plea bargain, because the gun didn't go off by itself. It was a Springfield Armory XD40 caliber. And I went to his office, and the defendant was there. He'd never threatened anybody in his life. He was out on bail. And basically, to make a long story short, what happened was the gun didn't fit his hand. He had no training whatsoever. He was just terrible with the gun. He was pointing it at me. He was pointing it at himself. Totally out of control. So and this is something that I've talked about this in this room before. With that particular gun, the magazine release goes all the way through. So it's a right-handed gun, as most are, but a gunsmith can outfit it because that thing goes all the way through and make it a left-handed gun. So what was happening, because his hands were small, he canted the gun in his hand to put his thumb over the magazine release, which put his index finger on the other side of the magazine release. So the harder he pushed on the magazine release, the tighter he had to hold the gun, the tighter he held the other side, and he couldn't get the magazine out, and he didn't know why. So he took his other hand and put it in here, and he's pushing with two thumbs, and in the process of doing that, his thumb hit the trigger. And I watched him do it in the conference room. And when it went click, he goes, "What was that?" And I go, "You just fired the gun." He goes, "No, I didn't." I said, "Yeah, you did." Now, the reason I tell you that story is because when we went in, again, we talked to the prosecutor and stuff, and I said the case was first-degree murder. Shot his wife in the side of the head. And we were going to get it to go down to negligent manslaughter. It was absolutely certain that we would get him down to negligent manslaughter. The prosecutor, hearing that, immediately called what they call a 402. They went into the judge's chambers, and the judge said 4 years, and that's what, 18 months roughly?
Yeah.
Yeah. So the judge said, we're going to make it negligent manslaughter, 4 years, you'll be out in 18 months. And I wasn't going to say his name. And the defendant goes, "I want to go to trial." And everyone is like, you could just knock this over. When the attorney called me and told me that, I go, "Did you not explain to him what he's doing? He wants to go to trial." So it was supposed to be next month, and they just kicked it to January. But you get the best attorney you can afford. Reagan's not available anymore, but get the best attorney you can afford, and pay attention to what they say. Because you're in uncharted waters. You really have no idea the intricacies of this stuff and how well, if a judge and I know this isn't right, but if a judge really hates an attorney, it's going to show up subtly.
Not so subtly.
And not so subtly. So, and the other thing, and I'll end with this, and I've seen this. There are people who will go out of county and get some highfalutin attorney from somewhere else and bring him into like Will County. How much do they like that? Yeah, you really don't want to do that. You want to find a good attorney in that county, in that jurisdiction, because he knows the judge, they know each other, and if you don't think that matters, it does. So, any questions at all?
I got a question for the panel, question for Judge Dave. Question for the panel. When you see television shows or movies, particularly television shows like The Good Wife, detective lawyers, stuff like that, how much of that is reality, and is any of them particularly good or that you like? And Judge, when it comes to Supreme Court elections, because last year or the year before we had a case before the Supreme Court that got kicked out, which was where all of us, 600,000 of us, signed a petition. Do they all stand statewide, or they only stand in their districts to get reelected, Supreme Court?
As far as the state Supreme Court, they run for retention in their respective districts. So our district right now, our justice is Justice Kilbride. He will be running in, I don't know if it's 2020 or 2022, but he'll be running for retention, and he runs for retention within the 3rd district. 2020. Within the 3rd district. Same holds true for Justice Garman, who is down in the 4th district, which is just south of here. Justice Carmeyer, who is in the 5th district, which is far downstate. And then Justice Thomas, who is the 2nd district, which is everything kind of north of here except for Chicago. But it's their respective districts that you vote for. So it's important that the organization and those who are concerned with it understand that it truly is grassroots, truly is each respective breakdown in where it is. Like for us, it would be all of you that live in Will County. In 2018, I know it is up for retention. There may be judicial spots open, but for retention, I know myself and a whole bunch of us are up in 2020. And so that would be the time where you should really look at those who are on the ballot.
I've not seen the TV show. Have either of you?
Oh, I'll tell you right up front. I stopped watching Law and Order because it was too much like work. They condensed it down. It was no escapism. The rest of the courtroom shows is just like a lot of bull, and that's one of the names of the shows. A lot of bull. It's just The Good Wife and all that, just a slight resemblance to what really happens.
I'll tell you that my family tells me I cannot watch them with them because I'm constantly trying to correct them, or it's too frustrating.
No, that's not how it works.
Yeah, it's too frustrating. It's to entertain you. I mean, if you come to court, I mean, Dave is very entertaining in his courtroom.
Thanks. I don't know if that's good necessarily.
Can we bleep that out?
No, he's a very good professional judge.
Yeah.
It's not very fun. It's boring. It's not, TV glamorizes, of course.
Any other questions?
I got one quick one for the judge. So I work under HUD, Housing Authority, and so I made an arrest on a 14-year-old, gang-related activity, in possession of a stolen, loaded handgun. So the prosecution, state prosecuting office, they sent that misdemeanor court. Why not felony? I have no idea. Then it gets misdemeanor court, and they plead it down to a warning, first-time offender. They're complaining about gun laws, need stricter gun laws. Don't enforce the ones they have. What gives a judge that right to not enforce the law and just say he can go?
Two things. One, and I can't comment necessarily on pending cases,
Right.
but I can tell you this. First and foremost, we changed the way we deal with juveniles a few years ago. And it used to be where if you were 17, you could be charged as an adult. Underneath that, there was always kind of a discretionary transfer, things along those lines. We changed that law. So now it's very much a automatic, if you are under 18, you are going to be treated as a juvenile. Once you're treated as a juvenile, the classification of offense, although we still kind of look at them as misdemeanors, felonies, whatever they may be, they're actually called delinquency petitions that are filed, and they're adjudicated delinquent. They're not found to be a convicted felon. They're not found to be a convicted misdemeanant. They're actually just juvenile delinquents, for lack of a better term. And so that, the entire way that is prosecuted, whether it's even in adult court, the charges themselves are brought by the prosecutors, and solely by the prosecutors. The judge can't do a thing about the charges. All we do is sit back and say either the facts are enough to go forward on it or not. But as far as actually bringing charges, it is solely within the discretion of the prosecution.
But Dave, it is true, though, that politics gets in there.
Oh, absolutely.
I mean, I've been before judges who I know are anti-gun, and it's obvious. There are things that you should be able to say, and they won't let you.
I think this is kind of what Reagan and Ed were talking about before. You know, there's personal. I used to tell everybody, and Doug, you were in not too long ago for jury service or jury duty. And I always welcome everybody on Monday mornings, which is the last thing they want to do is be there. And I always will tell people, you know, everybody, whether you're a judge, whether you're a lay person, whether you're a prosecutor or a defense attorney, you all have biases. We all have them. It's there. And anybody who tells you they don't have it, they're lying to themselves and they're lying to you. And so the key to our system is that we put those on the side. And it's hard to do. I'll tell you right now, it is one of the hardest parts of the job. I was a prosecutor, I was a defense attorney, now I'm a judge. I've done it all three angles of this. And the hardest single thing to do is separate your personal feelings, your emotions. I can tell you right now, anytime I deal with a kid or a case where a kid's a victim, and some of these things that are done are just barbaric and animalistic and everything else, and it hurts you. You want to cry. And you sit there and everybody's looking at you like this, and all you want to do is give this kid a hug. All you want to do is say, I'll make the world a better place for you. And you can't, because there's no way of fixing that. So all you have left for yourself is to rely on the facts and the law, and you follow that the best you can. So I don't know how else to describe it. But
Yep. Any other questions? Yeah.
One here. Yeah, the question I have is on judicial review. We hear that we have representatives in Congress and the state legislature, they make laws, and a law has to be, signed into law by a governor or president and so on. And in certain cases, we have judges who take it upon themselves to declare a law to be unconstitutional. This is one judge, when perhaps 100 other judges would think that this law is perfectly constitutional. So what kind of a judge does those kinds of things? What kind of a mental attitude do you have to have?
I should probably let one of these guys answer that one. Because I can tell you, just the Cliff's Notes version, the quick version of that is, if a judge finds a case or a law to be unconstitutional, it goes straight to the Supreme Court. So there's a certain way they deal with it for that very reason. We don't want trial court judges just coming willy-nilly saying, hey, you know what, I don't like this law, it's just unconstitutional, off you go. You know, on the flip side of it, we take it very seriously, and that's why as soon as that happens, all sorts of safeguards get kicked in, and it should go right to the Supreme Court. Reagan,
Yeah.
I don't know if you want to add to that.
Well, what happens is judge rules it unconstitutional, it goes up to the Illinois Supreme Court, and it's constitutional, sends it back down to the judge. Judge turns to the defense attorney and says, you want a bench or a jury? Bench. Put on a bench, prosecutor puts on an open and shut case, no defense, and the judge says, not guilty. And then he'll say off the record, the court reporter lifts his hands up and says, appeal that.
And the reason why Ed's saying that is because once a judge or a jury finds someone not guilty, it's over.
Yeah.
There's no appeal because you're not guilty. So the state can't appeal. If a radical judge decides that he wants to do what Ed just said and not follow the evidence that was presented and not follow the law and says, I find this defendant to be not guilty, it's over. There's nothing that the prosecutors can do at that time. So.
And that's why they had Gaylord, where they convicted 16 out of 17 judges in one swipe. You know,
Chicago.
Fixing murder cases. They had a black judge that fixed a murder case, and it was a hate crime. The guy was murdered because he was black. It happens.
Anybody else? Yes, all the way in back.
One problem I've been concerned with for years is there's no place that evaluates judges from a good conservative point of view. And it's just something, I wish somebody in this room might even start a website or something where they evaluate judges' performance, they lay people off unfairly, which was possibly done.
I'll answer this one.
Who should we vote for the certification as a judge, et cetera?
Yeah, I served 2 terms as the Will County Republican chairman, and I would spend hours researching the judges, what party they were at, and I especially looked at their dissenting opinions. Sometimes a conservative judge has to turn somebody loose because that's what the law says. But when there's like an opinion on the appellate judges, and it's 2 to 1, you look at what's driving each of those judges, and I'd make a list. And when I was the chairman, the most often phoned-in question to the party headquarters was, is this judge a Republican or a Democrat, and he's worth retaining or not? You know? And I would tell the people the unvarnished truth about the judges and give them examples.
If I can just add to that, one of the things I always say is the courthouse is one of the few places in the world that is always open. And my courtroom is always open to the public. And I invite people to come in and see what we do. The hard thing for trial judges is we don't write opinions. We deal with so many things in the course of a day. A lot of things are just on the fly. You know, I grant this motion, or I deny that motion, or I let someone out, or I don't let someone out. Those are the kind of things that we do in the course of 15 minutes in the morning. And so unless you sit there and actually see what the judges are doing, it's a huge undertaking. And I've always been in favor of having some sort of a group put together an organization that has court watchers. I think in Cook County they used to have them.
Yeah, they used to have.
That would be a good thing.
They used to have court watchers, and the judges would be entirely different people when there'd be a civilian in a suit with a special pad, and they would just be like perfect judges. And as soon as they leave, they go back to their old ways. And we as prosecutors, if we had a key case, we'd have a friend come in with the identical pad and sit up front recording things, and the judge would do the right thing because he thought that was a court watcher there.
So that would be the best way to do it.
I want to add one thing that just saying that kind of triggered this. Not that it has anything to do with it, but you know, I hear people say all the time, well, you know, I know the law says this, I can do this. And Ed taught me this lesson a number of years ago, and it was over Diggins. And if you're not familiar with Diggins, Diggins is the guy who was driving through Peoria and had a couple guns in his center console, and he got pulled over and arrested, and that's where we came up with you can have a gun in the center console of your car as long as it's not loaded. The ammunition can be next to it, but it can't be in the gun. So I was teaching that when Ed was developing our law program for concealed carry, and I always taught it so you can put a gun in a center console of your car glove compartment, and Ed goes, no, you can't. And I go, that's what Diggins says. And you remember this?
No.
You know, you're getting old.
I've corrected you so many times, I can't remember them all.
So he said, what the law says is you can put it in the center console of your car. It doesn't say you can put it in the glove compartment, right?
Oh, now that I told you.
And the problem is people extrapolate. They hear what they want to hear. And you gotta, when it comes to the law, you got to parse it. Each word has a meaning, right? I mean, words they're founded in law. And they have a very specific meaning. And you and me, for the most part, too, look at it and they go, well, that means not really. It means what it meant in that case, in that circumstance. And this is a good example. That example is the law says you can have it. Now, this is non-concealed carry. You can have it in the center console of your car. It does not say in your glove compartment. Now, I think most people would agree if you got caught and you went to court, you're probably going to get okay. You'll probably get off on it. But do you know what it costs to do this? If you're looking at a simple, if you're looking at a basic criminal trial, you're probably looking at $50,000 for something, felony.
Yeah, that's what I used to get paid in 9 months.
Yeah, well, it's tough luck. But and then if you want to go, if it goes to the appellate court, you should probably double it. And nobody gives you your money back. If you're found not guilty, you don't get your money back. You don't get your life back. You've been tied up with this thing. This one murder trial I'm on has been going on for probably 3 years now. I mean, it becomes your existence. So every time I hear somebody say, I want my day in court, I rag on them, just like I'm doing now. You don't. You don't want to be the canary. You know what that refers to? In mines, they have a canary in a little cage because they got tiny lungs. And they keep looking at the canary. And if the canary all of a sudden is like, they leave the mine, okay? Because they're next. You don't want to be the test case. Is that fair?
Yeah.
Yep.
Any other questions at all? Okay. Thank you.
Thank you.
Thank you.
Cool.
I'd like to say when I did have to go to jury duty, and we're all standing, we're sitting around wondering what goes on.